Well, hello everyone. I welcome you all at Smarty Education. Today we will be discussing with Law of Torts lecture number 2, and you are watching the lecture at Smarty Education. So let me begin with the lecture. First of all, let's see topics to be covered in this lecture. Number 1 is revision of previous lecture will be done, and second of all, we will study some famous case laws. Third, differences between tort and crime will be discussed. Fourth one is differences between tort and breach of contract will be discussed in this lecture. And the fifth one is kinds of tortious liability will to be discussed in this lecture. So first of all, let's revise lecture number 1, whatever we studied in lecture number 1. In lecture number 1, first of all, we saw meaning of tort. So what is tort? Tort law refers to set of law. Tort law refers to set of laws that provides legal remedies. Legal remedies means that is being provided by court to individuals who have suffered harm by the unreasonable acts of another. Unreasonable acts of another means whether intentionally or unintentionally you have harmed someone, then you are liable to pay the damages. Then we see the example of due to not focusing on driving, someone injured. Since even it was unintentional, I accidented into someone else's bike, it was unintentional, but still the victim can claim damages from me. That's what we discussed in previous lecture related to tort. If you have not watched lecture number 1, I suggest you to go and watch lecture number 1. You can even check the playlist at channel. Now then we discussed that tort is a French equivalent English word. Wrong means tort basically refers to wrong. It has so many meanings like wrong, twisted, wrong, twisted, wrong or crook. But every wrong or wrongful act is not a tort. What does it mean? In the previous lecture we said that breach of contract is not a tort because in the breach of contract we will discuss what is contract, but for now you can understand that breach of contract means the parties are related to each other and they know each other, but in tort parties don't know each other. So tort is a kind of really civil wrong as opposed to criminal wrong. Criminal wrong means which affects the whole society, but civil wrong is something which doesn't affect the whole society. It affects only the individual. Now wrongs can be either public or private. We discussed in lecture number 1. So what is a public wrong? Public wrong means violation of public law, and public wrong or offense means public wrong are punishable made under the Indian Penal Code. Indian Penal Code. Sorry for bad writing. And so what are private wrong? Private wrong are the breaches of private law, wrong against individual like tort. Then we discuss civil wrong versus criminal wrong. I have already told you what is crime. Crime means which affects the whole community, for example a murder. And then we discussed that what is a civil wrong. We discussed that in lecture number 1, A and B case, in which B entered into A house and broke the chair and A claimed damages for that chair. Then we saw some important definition related to tort. The first one was Salmon, second one was Fraser, third one was Swinfield, and we derived two conclusions from them. The first one was that a tort is a species of civil injury as a wrong opposed to criminal wrong. That every civil wrong is not a tort. Why every civil wrong is not a tort? Because breach of contract cannot be a tort. Then we saw some general conditions related to liability of tort. The first one is a wrongful act or omission of the defendant. Then the second one we saw that the wrongful act must result in causing legal damages to another. And the third one is wrongful act must be provided to some legal remedy. So what does it mean that legal remedy? Means the law should be able to provide a legal remedy that will be a condition under liability for a tort. Then we discuss what is a wrongful act. So the act complaint should under the circumstances be legally wrongful as regards the, so whatever I will be complaining, it should be a wrongful act according to law. So for example, right of reputation, right of bodily safety, freedom and right to property are violated without legal excuse, means without any proper reason. If you are violating these kinds of rights, then you are liable to pay damages. The wrongful act must result in causing legal damages to another. What does it mean? Let's get to understand this. So that every damage is not a damage in the eye of law. Why? For example, let's take an instant example. There was a fire in your neighborhood. You instantly ran to your neighbor's house and tried to water the fire, but owner said that you are entering into my house without my permission, and even you damage, but I didn't damage, that is not a damage in the eye of law. If you didn't get the example, comment down below so that I will reply you within 2 hours. Okay. Now let's talk about, in the absence of infringement of legal right, an action does not lie. Also, when there is an infringement of legal right, an action lies even though no damage may have been caused, as was stated in Ashby v. White. Look, this sentence you will get to understand in the Ashby v. White. Let's discuss Ashby v. White case. Let's understand case of Ashby v. White in case of infringement of a legal right where no damage has been happened. Okay. So there was an Ashby and there was election officer, as you are able to see in the example. This is Ashby and this is election officer. Okay, this is a foundational UK foundational constitutional law and English tort law. It concerns the right to vote. For example, this was Mr. Ashby who went to vote, but the election officer said that you cannot vote. Therefore, election officer somehow infringed his legal right. So what happened next? Let's continue our story. But before continuing our story, let me tell you what name from he will be known and what name from he will be known. So he will be known as tortfeasor who is applying for damages, and he will be known for tortfeasor that I explained you in the previous lecture number 1 of law of tort. So he will be known as tortfeasor and he will be known as tortfeasor. The court finally agreed with Ashby because his legal right of voting was infringed and the officer was found guilty and he had to. Now let me tell you one thing, that wherever you are studying law of tort, mainly no tortfeasor means defendant is not able to go to the jail because he has to compensate the tortfeasor or plaintiff. Now let's get to understand what is damnum sine injuria. So first of all, let's get to understand what is damnum means. Damnum means harm, loss, damage in respect of money, comfort, health, etc. And injuria means infringement of a right which is exercised by law on the plaintiff's side. The maxim means that in a given case a man may have suffered damages, and yet, so what does this say? That a man may have suffered damages and no action is sought because the damage is not an interest protected by law. So what does it say? Let me tell you. So whenever you are seeing a case of tort, first of all, there must be infringement of legal right, and the second of all, there must be some kind of damages. But this sentence is saying that a man have suffered damages but no actionable in tort because the right is not protected by tort. Let's see a good example to understand this damnum sine injuria. For example, there was a great coffee shop. People used to make a line to purchase coffee from that particular coffee shop. So now one day what happened that one day a cafe is open, a very good cafe is open, and some of the customers went to that cafe and the coffee shop owner suffered some losses and he went to the court. The losses that coffee shop owner suffered due to opening of cafe cannot sue cafe owner for damages as it was not infringement of legal right. Look, in this case what happened that coffee shop owner went to court to claim damages because of cafe shop owner. So the court said that there is no infringement of legal right under damnum sine injuria, therefore no compensation can be paid to you from that cafe owner. So what do you understand from this? There must be infringement of legal right to claim damages under law of tort. Now let's understand another term, Injuria Sine Damno. So first of all, let's get to understand what does injury means. Where there is no damage resulted, yet it is an injury or wrong in tort. Some rights or interests are so important that their violation is an actionable tort without proof or damage. So what does it say? Let's take an example. Thus the act of trespassing upon another's land is actionable even though it has not caused the plaintiff even the slightest harm. So what does the example say? Let's get to understand with a very good example. Injuria Sine Damno example. Please focus on this example. Very interesting example. So first of all, that there was Mr. Rakul was at his property and Shyam entered into the property and no damage has been caused by Shyam, but still Mr. Rakul can claim from the Shyam for getting into his property because he has violated trespassing, and without any harm or damage, Injuria Sine Damno will be applied and Mr. Rakul will get compensation from Mr. Shyam. Now let's talk about third condition for liability of a tort, legal remedy which provides remedy by the law. What do you understand by the term remedy? Remedy means Remedy, what does remedy means? Remedy means available solutions. This means that to constitute a tort, the wrongful act must come under the law, the main remedy for tort in action for unliquidated damages. What does unliquidated damages means? I have already told you in lecture number 1. Please write down in the comment section. Okay, if you don't know the meaning of unliquidated damage and you have forgotten, comment down below, I will reply you. Although some other remedies means solutions, injunction may be obtained in addition to damages, or specific restitution may be claimed in an action for the determination of chattel self-help. So wherever you are able to self-help, for example, Mr. Rakul can easily say to Mr. Shyam that you please go out of my property, this is my property and you cannot enter without my permission. So this was called self-help. But if the self-help is not able to solve the problem, then you can apply the forces. The best example is stress postulant that we saw in our previous example. Example of Rakul and Shyam that I have already told you here. Now let's talk about mens rea. How far a guilty mind of person is required for liability of tort. So let me first off tell you, in crime what happens that in crime mental, what does it mean? Why am I emphasizing on this one? Mental state of the person is also seen, but in law of tort mental state of person is not seen. Why? Itself create that no guilt in the act. First of all, remember this maxim, very important for your examination point of view. The act itself creates no guilt in the absence of guilty mind. It doesn't mean that for the law of tort the act must be dealt with. So in law of tort what happens that even if you don't want to do that but somehow it happened, you are still liable to pay the damages, but with an evil motive you have to pay the damages. Okay, so now let's understand the concept of crime. For example, someone has been murdered, his blueprint is here. So what do you understand from this? Is it against the country laws? Yes sir, it is. So what is crime? A crime means is an act done by a person which is against the laws of a country or region. Things like killing another person, injuring another person. I hope you got the concept what is crime. Now let's see difference between crime and tort. Infringement of legal right. Breaches of public right affects. So in crime what happens that breach of public right affects whole community, whole society will be affected due to killing of someone. Now in tort what happens that it has happened to an individual person. For example, the case of an accident that we discussed in lecture number 1. Now what is an objective of crime? The objective of crime is to punish the defendant in a crime, but the objective of tort is to compensate the plaintiff. Now let's take a very good example to understand what is contract. For example, there was a Mr. A who owned a very nice car Ferrari. One day Mr. B came to him. Okay, Mr. B came to him and said that I want to purchase your car. Will you sell it to me? Mr. A said that definitely I will sell it to you at the price of rupees 5 crore. Mr. B said okay. Now let's discuss what has happened between them, what kind of communication they did. So A and B contracted in which A will sell car at the price of rupees 5 crore. B agreed to pay that price, but B put condition that you have to deliver the car before 10 am, and if you deliver the car after 10 am then I will only pay 2.5 crore. So B put a condition. First of all, if you deliver the car before 10 am, I will pay you 5 crore. But if you deliver the car after 10 am, I will pay you only 2, means half of the amount will be paid. So Mr. A consciously thought that this is a very good deal. I can deliver the car before 10 am. So I must go for the risk. So they contracted between each other. Okay, so next day what happened that as you are already seeing in the clock that it's already been 11 and Mr. A somehow reached at the specified place of B, but Mr. A was only paid 2.5 crore. Why he was paid only as per the contract details? So lessons to be learned from this example. The first one is damages are already fixed between parties in any kind of contract. Breach of duty. So if anything goes wrong, what will happen? It was decided between A and B. Example. Now let's discuss difference between breach of contract and tort. Okay, so fixation of duty. In breach of contract, duties are fixed by parties that we shine our example. In tort, breach of duty is fixed by court or law. Damages in breach of contract, damages are fixed between parties. In the example of us, damages of A and B, in which A delivers car to B, damages are already fixed that if anything goes wrong, I will pay you only 2.5 crore rupees. In law of tort, damages are unliquidated and decided by court. Now let's discuss kinds of tortious liability. Very important topic from your examination point of view. The first one is strict or absolute liability. Second one is vicarious liability. Third one is vicarious liability of state. Let's discuss them one by one. So what is strict or absolute liability? First of all, consider two words, strict and absolute. So what does strict mean? Strict means strict means discipline. Strict means something hard. Okay, strict means I can say that my teacher is very strict. He doesn't bear any kind of negligence. So strict means something which cannot be changed. The defendant is liable even though harm to the plaintiff occurred without intention or negligence. Even without intentional or unintentional, you are able to pay the damages in court. In other words, the defendant is held liable without fault. Even if it was a mistake, you will be liable under the tort. Liability for inevitable mistake. What does liability for inevitable mistake mean? Such liability arises in case where damage is done by the escape of dangerous substance. For example, you kept a lion in your house and the lion escapes. This will become under liability for inevitable mistakes. Now let's discuss liability for inevitable mistake. Liability for inevitable mistake. Another case. Such case where a person interferes with the property of another means you have violated trespassing. Third one is vicarious liability for wrongs committed by others. Kare koi bhare koi. Responsibility in such cases is imputed by law on the grounds of social policy. We will discuss its explanation in the further upcoming slides. First of all, let's move on. Let's discuss a very famous case law, Ryland versus Fletcher case. So what happened in this case? Let's discuss. There was a person named Ryland and there was a person named Fletcher. Ryland was owner of mills. To power his mills, he contacted some independent contractors. So he said to independent contractor, will you build a reservoir for me? Independent contractor said, yes sir, we will do it for you. Okay, if you pay sufficient amount. Then the deal was done and the contractors and the independent contractors built the artificial reservoir, and after getting the payment they moved on. So one day what happened then the rain started and the reservoir was overflowed, and somehow after the rain due to breakage of this artificial lake, Fletcher's crops were damaged. So Fletcher went to court to claim the damages. So before continuing our story, Fletcher will be called tortfeasor and Ryland will be called tortfeasor. So what happened in court? So first of all, Ryland said that this is the fault of his independent contractor. Okay, so but the judges said that the fault is of his in contractor for negligence of a coal shaft. But the judges said that fault is not of his independent contractor. Sorry for mistake. Fault is not of his independent contractor for negligence of coal shaft. But judges said that first of all, this was non-natural. Building an artificial lake was not natural. And second of all, you were negligent to observe a coal shaft. Because of coal shaft opening, the water went to Fletcher's field, and Fletcher and the Ryland had to finally pay the Fletcher. Okay, and the damages were paid by Ryland to Fletcher. Now let's discuss another things. Later in the case of Reed versus Lyons, okay, it has been, you don't have to remember this case study. So necessary two conditions are necessary to apply the decision of Ryland versus Fletcher case. First of all, escape from a place which the defendant has occupation, or over which has control to a place which is outside his occupation or control, or something likely to do mischief if it escapes. For example, you kept a lion and it went out, it will be called as escape. And the Ryland versus Fletcher case must be done. Non-natural use of land. So first of all, what did Ryland did? Ryland first of all made a pond into an artificial lake which was unnatural. Okay. So that's it for today's guys. I hope you liked the video, and if yes, please give it a big thumbs up, and in the description box you can find the number to join my WhatsApp group. So that's it for today's guys. In the next lecture we will discuss with exceptions to the rule of strict liability.